thank you everybody for joining the call. I'm Jonathan Young from Loch Lord, and together with my friends Chris Armstrong, Satwinder Singh, and Alexandra Shlukamand, we co-chair this group. And we've been really pleased with just the level of participation and the number of different firms that have sent people to join our discussions. And, you know, one of our, as I've said on other calls, you know, I think one of our thoughts about this group is that restructuring is really a practice that ends up touching a lot of other different parts of our firms. It bridges, you know, transactional and litigation. And in terms of, I know the focus we all have on, you know, finding opportunities for each other and driving referrals, I really have always been of the view that our practice area is a great place to do that. So happy to see you all this morning. I think our thought for today was we would go around the horn and hear from people some of the developments, both from a market perspective and also from a legal perspective, what's going on in your jurisdictions. And then I was going to present on some recent legislative developments in the U.S. That have been getting a lot of attention, and really use that as an opportunity to, you know, hear further thoughts you might have about similar developments in your jurisdictions. And we're going to finish up with a brief discussion of some of the executive compensation and retention arrangements that have been put in place in the Purdue Pharma case. And Xiaotong Tan has been kind enough to join us today from Wong Partnership to address those issues from an executive compensation perspective. I'll set the table for him by describing on a general level what Purdue Pharma tried to do. So that's our agenda for today, and glad you're all here. And Hannah, if you want to kind of queue up whoever's here for the first time to introduce themselves and tell us a bit about themselves, that'd be great.
Sure. I know we have a couple of you, and just raise your hand if I've missed you. Lawrence, I think this is your first meeting with this group. Is that correct?
Yeah, that's right.
Do you just want to take just a quick minute to introduce yourself?
Sure. Hi, everyone. My name is Lawrence. I'm from Wong Partnership in Singapore. That's the same firm as Xiaotong as well. And I cover restructuring and insolvency in Singapore as well as Indonesia. I've actually spent the past 6 years, half my time in Singapore, half my time in Indonesia. And it's a pretty interesting and exciting time for us because, as you may know, Singapore is quickly developing as the regional restructuring center of Southeast Asia and hopefully Asia Pacific. So Singapore being a very small jurisdiction, obviously a lot of the work that comes in is going to be from our neighboring countries. And Indonesia, with the biggest economy in Southeast Asia, is definitely the hotspot for us, the target for us. So quite a few of our cases that have been quite interesting that have come in recently are from Indonesia, no surprise there. And we've seen a few cases that have come in using Singapore as a center for restructuring. Restructuring either the Singapore law-governed bonds or the New York law-governed bonds, and then using Singapore as a platform to try and get cross-border recognition in the US as well. So there've been, I think right now, PT Modern Land is one entity that's seeking recognition in the New York courts as well. And they've really gotten recognition in Singapore. So they are really using a lot of these new tools that Singapore has kind of adopted from the US, such as pre-pack schemes. A lot of these companies, the Indonesian companies, have used that to quickly pass a scheme of arrangements through in Singapore, and then subsequently try and get it recognized in Chapter 15 in the US. So Singapore adopting the cross-border model law as well has been extremely helpful in that regard. And yeah, you know, we see probably a lot of Indonesian debtors coming to Singapore more and more often, and potentially using Singapore as a principal center of restructuring. Yeah, so that's just a quick update. There have been quite a few other interesting developments in Singapore as well, but if I have more time, I can share that later on.
Thank
Great,
you very much. If I could just jump in, Hannah, thank you very much. That's great to hear. Great to have you with us. Hope you'll come to further discussions. And I'd love to catch up with you offline and find time to introduce you to my partner in London, David Grant. He filed the first successful recognition proceeding for the Singaporean statute in the UK. So he's quite familiar with it, and I'm sure would be really glad to make your acquaintance. And for what it's worth, it sounds like quite a good statute. Sounds like they did a good job with it, and you're going to see more opportunities coming out of that, which is great.
Yeah, thanks, Jonathan.
Thanks, Lawrence. And of course, we have your colleague, Xiao Tong Tan, who's going to be presenting or chiming in with us later on the Purdue case. But Xiao Tong, why don't you just take a quick minute to introduce yourself now?
Yeah, hi everyone. My name is Xiao Tong. I'm from the tax practice in Wong Partnership. So I must say I'm not really the restructuring expert. I'm glad Lawrence has joined. He probably has much more input that I have, but certainly I'll be happy to share with you all some thoughts that I have on the Purdue Farm case later. In fact, I didn't even realize Lawrence was joining. That goes to show how much COVID has sort of changed our lives because we are all working from home.
Thanks, Xiao Tong. We look forward to hearing from you later as well. Manuel, in Spain, is this also your first meeting with this group?
I joined this meeting before the summer, but well, it's my second one, so good to see you all. I'm a partner at Cuatro Casas, specialized in banking and finance, and also restructuring and special situations. We hope to have some news in the coming months, since we are going to have a new insolvency law before December. So probably we will have big changes on the existing one. Of course, we will send you a newsletters and some input of our jurisdiction when this is approved finally.
Great, thanks, Manuel. And then Christian, is this your first meeting?
Hi everyone, my name is Christian. I'm from Taylor West, Germany, bureau in Munich, and not doing that much restructuring work. I'm specialized in advising insolvency administrators and trustees in larger national and international insolvency proceedings. So I'm mainly focused on the procedural enforcement and defense of insolvency-specific claim and clawback actions. That's like 90% of the time I'm working for administrators, and we see a rise in those cases, in international cases, where we represents the German insolvency administrator, and he's initiating a clawback action against a defendant that has this registered seat in the US or in Switzerland or in the EU. The other colleague here, my colleague Henrik Bossi, is doing the classical restructuring work. So we have like we're 10 lawyers here, and he's focusing on this the structural advice of managing directors, creditors, companies in distress situations, and I'm heavily specialized advising administrators and trustees. So glad to be here and nice to meet you.
Great, thanks, Christian. I think that is everyone who we've had for the first time. I think the rest of you here are fairly regulars with us.
Great. Well, glad to see everybody. And I'd like to kick it now to my co-chairs, Satwinder and Chris, and invite each of you to give some opening remarks. And then I thought what we would do, and perhaps you could start us off on this, Satwinder, but I thought what we could do is just provide a brief update, both of what's going on in the debt and restructuring markets in your jurisdictions? You know, are you seeing a continuation of relatively easy and cheap credit? Is credit tightening up? You know, what's happening, you know, in the larger market in terms of consumer sentiment and default levels, and then any, you know, recent legal developments you might have seen. And if there's not a lot going on, no worries. I just always think it's useful to touch base on these calls and have all of us hear what's going on in the different jurisdictions. So Satwinder, might you start us off?
So thank you, Jonathan. I think the important aspect of right now, the new development which we are talking about is that the regulator has come out with the draft regulations for the cross-border insolvency positions. As you know that, okay, the law is evolving, the jurisprudence is evolving, and you look at it from that angle. We are tackling, as you know, that one important factor which is coming up is like we had the Jet Airways assets are outside, how we can enforce the order of the Indian tribunal as far as the jurisdiction outside India is concerned, and even where the creditors outside India are there. So you see, and they have to enforce their claim. How far it would be practical? So if I see this right now, there is only an enabling provision which has been given in the code under section 234 that the central government will enter into the agreements with the respective countries. But till date, the government has not yet entered into. They are just looking at into the UN CITRAL model regulations, trying to amend it with the Indian law requirements, and seeing that how if there is a order by the Indian tribunal on that insolvency, if it is to be enforced. The way today I look at it is that, okay, if it is there, probably the foreign jurisdictions will not easily accept, and they will, you have to, you see, file a separate applications, and if there are already any attachments in the foreign jurisdictions, how it will be respected too. So those are the issues which are, you see, important issues, and the draft regulations to talk about the foreign proceedings if the reciprocal agreements have been entered into. So those nitty-gritties like the foreign main proceedings, foreign non-main proceedings, and then the jurisdiction will be depending upon the level of control that has to come. And I was just looking at it as, since you are going to have a presentation on the employees' compensation. So I was just thinking that what could be the issues which even can come on that part is where Indian entity has a branch office outside India and there are foreign employees. And here you see there is a water flow mechanism has been given to the extent of where they can get the compensation, and then the law provides for the extinguishments, and any prospective resolution applicant who is coming, they are saying that there should not be any head popping, and the person will be given a clean slate to start afresh on this. And now these are the issues I think are coming. And the other important aspect which is coming up is the group insolvency, where the assets have been entangled within that same group. There are corresponding commitments given by the group companies to the same lenders and other things, rather than otherwise. As of now, the law provides that, okay, if there would be insolvency, it will be only a particular company if it is that company is in default. But if there are many companies and other thing, and you are looking for the prospective resolution applicant, why not club all that applications and look for you see, resolution for the entire group as a whole. So those are the things which are really coming up, and the regulators are working on it. And I'll update you as soon as those regulations would be up, making to that part.
Satwinder, thank you so much. All good to hear. Chris, can I kick it to you?
Sure. Morning, everyone. Chris Armstrong, Goodman's in Toronto, Canada. I think, fair to describe the restructuring landscape as patchy. The pipeline is reasonably slow right now. I think that's a function of, as it was, for most of 2021, just a lot of cheap money in the market, as John was suggesting. I think the U.S. has seen the same thing. A lot of government money as well, although the taps have kind of finally started to slow on that front in terms of direct funding from the Canadian federal government. What we have seen is a ton of issuance of high yield debt in the last 3 or 4 months, typically on 3-4 year maturities. So that is going to drive the next cycle here, hopefully, as the frothy markets always do. In terms of legal developments, there has not been any notable statutory changes in Canada over the course of the past year. I think the one interesting development kind of in practice in the past year, and I'll apologize if people have heard this before, is there continues to be a lot of use of this, what we call reverse vesting orders. And that is, your typical, use the US parlance, 363 free and clear sale, where you convey assets of a debtor on a free and clear basis of claims and leave the liabilities behind the debtor estate. This kind of new novel reverse vesting order it basically allows you to preserve the corporate form. And so essentially you do a share deal in an insolvency and cleanse the corporate debtor of unassumed liabilities. So, financial debt, basically anything you want. And that has been a very popular restructuring mechanism in the last year. And there's a ton of advantages to it from a structural standpoint. For instance, if you have regulatory licenses, as a lot of our industries have, whether it's the emerging cannabis market, whether it's telecommunications, pursuing a reverse vesting transaction is just a much better way to get a deal done. You're able to preserve tax loss attributes and the like. So we'll see where that goes. It started to get some pushback from our courts because there is, I think there's some allegations of kind of abusive practice in that, in terms of basically getting to a plan-like outcome without a creditor vote. But so far, no statutory changes and no real pushback from the courts, although we're starting to see more caution on that front. And that's it for Canada.
Thank you so much. Gregory, could we go to you next? Yeah, you're muted. Sorry.
Sorry, I had some issue. No, it's unmute. Hello.
There you go.
Not a lot of change here in Belgium for the time being. Slide in the we have the different type of insolvency proceedings. One of that is the judicial reorganization, which is a kind of a Chapter 11 proceedings. It has been slightly amended in the first part of the year in order to adapt to the coronavirus measures. But the biggest chance is announced for the first part of 2022, because Belgium has to transpose the EU directive regarding the reorganization and the protective measures. So we expect to have the transposition of this directive into Belgian law. The most notably change will be an adaptation in the reorganization plan, because for the time being, the debtor has to present a reorganization plan to its creditors, and the creditors must vote on the reorganization plan. But there are only two different categories of creditors who can vote on the reorganization plan. But in the future, it is provided that there will be more category, and it will be needed to have a majority in each part of the category of creditors, which is a big change under Belgian law. But we do not have a draft bill for the time being, so we expect to have a draft bill by the end of the year or beginning of next year. And last notable change here in Belgium, that's for the time being, there are lots less reorganization of insolvency proceedings than before the coronavirus crisis due to the state aid measures. But it is also expected that in the future, in the coming month, it will be a lot of insolvency proceedings due to the fact that the measures will not be applicable anymore, and that the debtor will have to reimburse the aid. And so we expect to have an acceleration of the number of insolvency proceedings. That was for Belgium. Thank you.
Interesting. Thank you so much.
You're welcome.
Daniel, can we come to you next?
Yes, sure. Many thanks. So from the German side, yeah, regarding new developments in German insolvency or restructuring law, there is not that much to tell. We already mentioned in one of our last conferences our new Reorganization and Restructuring Act. So this is what was really new at the beginning of this year, but this is I reported about that already, I think in April, or when we had the last conference like this. So maybe the more actual developments are in these, I would say, supporting measures of the German government regarding the COVID crisis. We had things like a suspension of the duty to file for insolvency, or support by short-time work and payments of salaries of these employees by the state. This is at the moment expiring or already expired, which might bring some pressure on the market and to some of the companies who were really saved by that. But we don't see that at the moment. We have to wait and see how this develops. So maybe another look at the general development of the German market when it comes to restructuring or insolvency situations. There it is that you at the moment have a market that is still influenced by a quite easy access to very cheap money, which makes it more preferable to go into refinancing situations than in going into really hard restructuring situations at the moment. And it leads to a situation where we see here in Germany quite very few larger restructuring situations at the moment. Well, however, we have some very new developments which I would like to mention, which have to do with the German real estate market. On the other hand, on the one hand, we have these market of commercial property under pressure since COVID crisis, and this is still developing. So we have some larger asset managers that we see under pressure at the moment, but not so far that they are already in a restructuring. And the latest development we have seen here during the last 2 or 3 weeks is that we have, but this is a local phenomenon. We have seen that the residential real estate market in Germany comes under pressure. Maybe you have read about that. There has been a study by, I think, UBS was the bank that published this study, and we had especially here, you see behind me, the Frankfurt residential real estate market is seen as maybe one of the markets with the largest risk for a huge bubble. And at the moment, when you talk to the guys in the market, this is something that is really interesting, and everyone is quite a little bit waiting what will happen next in this market. But this is what we really can tell about recent developments here.
Thank you. And how are our friends in the automotive industry doing with their chip shortages?
This automotive thing, if you ask me, is we are talking about automotive and restructuring since at least 5 years now, and we come up with new reasons every year. At the moment, of course, we have this chip crisis. This is a problem, and a lot of people see this as maybe the final trigger for some of the companies to go into restructuring situation. But we haven't seen that at the moment. So we really have to wait and see if this is really the final trigger. I was talking to some of the insolvency administrators who have done a lot of insolvencies in this market in the past. They are quite positive from their point of view that these situations will come maybe into really hard restructuring situations or even insolvency situations. But at the moment, this is not the case so far.
Yeah, thank you. Christian, just to double up on Germany, anything else you want to add in terms of what you're seeing? Rate of default, industries in trouble and such?
No, not really. I agree with that analysis by Daniel. It's like you said, we still don't see a substantial rise in insolvency cases, and that's due to the reasons Daniel pointed out, and the cheap money in the market. And yeah, let's wait and see if that changes in the next 2 or 3 months.
Yeah, very good. Thank you, Guy. Glad you're here. And anything you want to add for Cayman? Guy, can you hear us? You're muted. You're muted if you can hear us.
He may have been having connection issues because he's come in and out. So that might be his problem.
Okay, no worries. Manuel, anything you'd like to share from the Spanish perspective?
Yes, as mentioned, we are waiting for a new insolvency law for end of the year, which will incorporate some contents of the EU directive. Regarding the moratoriums, suspension of duty to file for insolvency, aids given to companies and corporates, we have a situation similar to the German one, in which the government is finalizing all those measures. For example, the moratorium for insolvency, it was foreseen until this December. Finally, it's going to be next March, 2022. But after March 2022, all those aids are going to end. So we expect that some companies will file for pre-insolvency or even insolvency directly, because they are not going to live. One of the sectors that has been more affected in Spain has been the hotel and tourism, and now we are seeing some bargains on especially on hotels, and that's why funds are entering with loan to own. They are willing to give loans, but of course with thinking about taking the shares by a share pledge. Now we are seeing that this is going to be what we are going to have in the market for the next years, at least with funds. Regarding financial entities, they have been very patient. We have not seen big refinancings because it was impossible to have a business plan. It was not possible. So we have formalized a lot of waivers, a lot of small novations, also covenant holidays. I think that I'm sure that all of you has faced more or less the same in your jurisdiction. But since in 2022, things are going to change, no more aid from the government, and also a clear picture of the incomes of the corporates and companies. I think that we will face two different scenarios. On the one hand, big restructuring, and on the other hand, insolvency. And now we have been like in the, it has been a strange year because at least when we end 2020, we expected all this that I am just discussing to happen in 2021. And finally, since the government has made big efforts to maintain this situation during this year, we think that this finally will happen on 2022.
Thank you very much. I was just thinking, with your comment about you can't do a business plan, you can't do a valuation. I mean, it's really been a crazy year and a half in restructuring. I mean, all the evidence-based determinations you make to figure out what to do with a company have really been out the window. So I think wherever this goes and whenever it goes, I think it definitely feels like we're headed toward the end of something and the beginning of something else in terms of the cycle. So thanks for those comments. Let's see. We're going to let Xiaotong talk in a moment. Lawrence, I know you gave us your comments previously. Anything else you want to tell us about the market right now in Singapore?
So I think for Singapore, the government during COVID has implemented various reliefs that have essentially placed a moratorium on any enforcements essentially against various debtors. So that has allowed some holidays for a lot of these companies that would have been in default otherwise. A lot of the industries that are under stress would be the construction sector, would be the F&B and hospitality sector, as you would imagine. And also the retail sector, actually the physical retail, especially we've seen a few big stores close down. And we think most likely going forward, given how everyone has gone into essentially buying everything online, that industry is not likely to come back. So we're probably going to see a lot more insolvencies there. But generally, because of the various COVID measures that the government has put in place and the economic stimulus packages, I think there haven't been a lot of big restructurings. Those big restructurings that we have seen and we are involved in are more stressed or very, very stressed companies that were already showing all these signs pre-COVID. And essentially, COVID really exacerbated the situation and pushed them into restructuring or insolvency. That's for Singapore. For Indonesia, which I cover as well, it's very, very similar. But I would say it's probably a lot more magnified because already before COVID, the banks were facing a very difficult NPL situation. It was very strongly rumored that although the NPLs that were reported were 2%, but actually it was a lot higher and closer to 6% even. And a lot of industries really very stressed. The commodities industries were very stressed. The property industries were very stressed. And with COVID hitting as well, I think what a lot of the banks have done is to push the can down the road. So a lot of them have had no choice but to refinance given the NPL situations. And the other area that we see a lot of stress in is the state-owned enterprises in Indonesia as well. So how the Indonesian government has approached the situation is to basically try and repackage all their non-performing SOEs under one sort of umbrella non-performing SOE and try and restructure it that way. So it's quite interesting to see how they are going to restructure all these SOEs, either by way of combining them together, or essentially letting them go into default and go into insolvency. Oh yeah, and one more other big sector which I haven't mentioned is aviation. So in the region, obviously Singapore Airlines have had the benefit of the government really supporting them, Temasek, the sovereign wealth fund really supporting them. But we see now neighboring countries like Malaysian Airlines having forced to go to UK to get a scheme of arrangement for that. And also in Indonesia, Garuda is potentially seeking the same as well, going to UK to try and get a scheme of arrangement to protect any enforcement claims against the lessors. So we're seeing quite a lot in this region. In terms of case law developments, there have been quite a lot. Like I mentioned just now, we have implemented a large host of reforms, and essentially now is really refining and allowing all the cases to go through the courts to see how the courts will adopt these reforms essentially, right? And on top of that as well, given how Singapore is so regional, another very important aspect is harmonization across all the various regional jurisdictions. So Singapore obviously is a signatory to the Judicial Insolvency Network. And through that, we have managed to work very closely with the US, for example. In Ezra and IMA Shioda, for example, we managed to get cross-border recognition with US Chapter 11 cases. But now we are also trying to enter into various cooperation frameworks with the other regional jurisdictions. So just last month, we signed one with Malaysia, where basically both courts in cross-border insolvency cases will work together, will communicate, will try and find harmonies in our approach towards cross-border insolvencies across Singapore and Malaysia. And we do look forward to a lot more of these cooperation frameworks and protocols to come out in the near future.
I think I'll just add a little bit more to what Lawrence has said about the Singapore landscape. Frankly, COVID has not proved to be as detrimental to the economy and most of the companies in Singapore as a whole. We are on, I think the sentiment is that we recover quite well, I think at least this year, even though we are in somewhat of a semi-lockdown again. I think like what Lawrence said, a lot of companies that we have seen in trouble are actually companies that actually were already in trouble before COVID. And a large part of it has to do with the support that's been given by the government in terms of wage subsidy, I think up to 70%, 70 for certain sectors like aviation, hotel industry. Of course, those are being wound back already now that, you know, the expectation is that things are going to be better. There's also the property rental relief, which the government actively sort of dish out to all the tenants to sort of alleviate their rental burden. So I think that has helped the companies a lot. I think on the individual income tax front also, there's a lot of deferral of payment of income tax, as well as providing certain exemptions for people that are stuck here in Singapore and can't go back to their country. So all that have helped. But these are also all being wound back now. So it's back to, I think, business as usual very soon.
Well, thank you both for that. It's very helpful and very good information. Eduardo, very nice to see you. We have a short window before we switch to the next topic, but do you want to take 2 minutes and tell us what's going on in your jurisdiction?
Well, I'm basically joined. Hi, I'm Eduardo from the Dominican Republic. I'm joining because insolvency and restructuring, it's basically still in its infancy here in the country. Although we have a restructuring law from a couple of years ago, only 2 companies have used it. So there's still a lot of growth to be done here in the country, a lot to be learned by lawyers and even the private sector. So I'm basically just glad to sit here and hear everybody's experience to see how we can help further grow this here.
Well, really glad you're here, and thanks for that. And thank you all. So let me shift gears, and I want to tell you about 3 very sort of hot burning fires that are that are taking place in the United States from a legislative perspective. And then I'll use that to set the table for what Xiaotong is going to tell us about. But there are three issues that very much are on the minds of restructuring practitioners in the U.S. And they are what I call non-debtor releases, releases that benefit affiliates and parents and individuals other than the entity that's under court supervision. What we call equitable mootness, which is a doctrine that essentially defeats an appeal of a Chapter 11 plan confirmation on the theory that even if the court's ruling were unwound or reversed, it would be too difficult to unwind everything. And then just the question of venue reform. A substantial majority of our largest cases are filed in either Houston or New York or Delaware. And many constituencies are questioning whether that's a good thing. And all three of those issues have seen legislation proposed on Capitol Hill in Washington to address the issue. I circulated on the email server last night, I believe, the venue reform statute, which would basically require companies to file in the jurisdiction where their headquarters or principal assets are. And then I sent something around that proposes to prohibit the release of a non-debtor party. The case that really has driven a lot of this discussion is the Purdue Pharma case, which really, I think, focuses on the opioid epidemic worldwide and certainly in the US. And billions of dollars of claims have been asserted against Purdue Pharma on the theory that they made a product, OxyContin, that has just killed a lot of people and hurt a lot of people and doesn't really have any redeeming social value. And the company was inundated with these lawsuits, and many of them were directed at the Sackler family, which founded the company and really, in the view of many, was responsible for not only developing the product, but marketing it so aggressively. And the Sacklers were able to use the non-debtor releases in Purdue's Chapter 11 plan to basically cut off all of their liability going forward for the opioid epidemic. I think they paid, the final number was in the range of $4 billion. And they got a clean bill of health from a liability perspective going forward. And it just enraged a number of people, just on the theory that the Sackler family had $12 billion in assets and they had essentially caused the opioid epidemic. And how could this be? And non-debtor releases have been controversial in the United States because there's really not a very clear statutory basis for them in the U.S. bankruptcy code. So right now, the legislation is pending. It remains to be seen whether it will pass, but it's just a great example, and we've seen it in all of our jurisdictions, that sometimes really extreme facts really can move changes in the law, where less controversial cases have not. So, it remains to be seen how quickly that'll progress or whether it will stall out. I think many of us have seen restructurings where, we've used it as a tool, I think hopefully in less controversial circumstances and, less terrible facts, but it is useful when you're representing a debtor to be able to utilize those releases. I know, Chris, we've talked about it, how it works in Canada, and it's an important tool there, but that's very much on the mind of people in the States. Equitable mootness is a less extreme set of facts, but it's almost like people in the U.S. have suddenly kind of waken up and said, we've got all these really substantial legal issues that are being decided at plan confirmation, and they're really just not getting reviewed by a higher court, because the doctrine of equitable mootness says if you have in effect consummated your Chapter 11 plan, if you have started to fund it and started to distribute shares and not even finished the plan process, but just started it, that's too difficult and too challenging to unwind, and therefore, unless you're able to stop the plan process from moving forward and stop the plan transactions from being consummated, you never get an appeal. And a number of constitutional scholars have said, wait a minute, bankruptcy courts are courts of limited jurisdiction. We've got to have federal district courts and appeals courts and eventually the US Supreme Court reviewing these matters, because a lot of complicated legal issues are being decided at the bankruptcy court level, and it can't be the case that it never reaches a higher court. So that one is not bad facts. It's sort of really a jurisdictional hole that I think everyone is trying to plug. And then with regard to venue reform, it's fascinating. Joe Biden, before he was our president, was a senator from Delaware, and Delaware has always enjoyed a major portion of the U.S. bankruptcy filings. And Biden, as a senator, was very influential in blocking venue reform. He's not really able to do that, or maybe even motivated to do that right now. And you have judges in places like Maine and New Mexico and Utah and Chicago saying, wait a minute, why are companies in our jurisdiction going to Delaware, Houston, or New York? And the reason is pretty simple and straightforward. It's that those jurisdictions have developed really good process. There's a lot of predictability in terms of what those judges are going to do. And, if you're able to venue in Delaware or Houston by incorporating an affiliate there, which is what the present state of the law is, why shouldn't you be able to do it? Just as a company might choose to domicile in Delaware for corporate law purposes or board protection purposes. So again, in some ways that may be, even though it's the simplest legislation, it may be the most challenging to pass, because there has always been such a strong sentiment in the restructuring bar to be able to access these favored jurisdictions. So that's really my report on the legislation. Again, hard to predict where it's all going to go. I do think we're going to see something happen on non-debtor releases. I think people are too angry about the Sacklers, and it may not be an outright prohibition, but I think the circumstances under which they're going to be allowed will be tightened up. As to the other two, we'll just have to see. So let me pause there before we finish up with executive compensation and just see if anybody has any questions or comments on any of that.
John, has there been any in dealing with the non-debtor releases? Has there been any focus on, kind of the scope of the release, versus just kind of all or nothing in terms of having releases?
Well, yes. That's sort of the compromise position that gets offered. I think what has people looking for a kind of a maximalist solution is you're very rightly describing a sensible solution that has been, really the approach taken in the case law. Like if you look at the Metro Media case out of the Second Circuit, or similar cases in other circuits, that's supposed to be the standard. The cases say it's got to be extreme circumstances, it's got to be absolutely essential to the reorganization. The people getting released have to make a really meaningful contribution. And to give the Sacklers their due, I mean, $4 billion is a pretty meaningful contribution. I mean, they're not getting it for nothing. But I think the growing frustration is that you have a reasonable standard, but just every time a major case comes through Delaware or Houston or Manhattan, and here's where venue reform comes back in, the release gets rubber stamped, and what you get, at least arguably, isn't proportional to the release that's given. Similar in Canada?
Yeah, that's right. I mean, that we have a common, similar to the U.S. There's very limited statutory basis other than the kind of general provisions that allow a court to make any order it considers appropriate in the circumstances. But a similar case law, I think, to what you just described, has developed. The focus is on the contribution being made by the non-debtor release parties and whether the releases are in effect integral to the plan. I think the way, in terms of the scope of the release, there's been continuing commentary, that fraud and willful misconduct should be carved out of those types of releases. But there's no, in some sense, there's no real basis for that, because at least under our law, unless it's statutorily prohibited, you can have any provision in a plan that's lawful provision of contract. And of course, people release fraud or willful misconduct all the time. In fact, some people say that that's the whole point of getting a release. What we haven't had is a case like Purdue, for instance, to kind of focus the mind on those issues. As you suggest, most of the non-debtor third-party releases that have been proved in Canada are kind of tacked on to your very typical, corporate arrangements where they're really just belts and suspenders in terms of, protecting anyone taking a shot at the plan or the parties after the fact. Interesting. We do have the three main tobacco companies in Canada, Imperial, Rothmans, look at the Canadian subsidiaries of all these big tobacco companies that have been in CCAA, I think, for almost 3 years now, working away at a plan. So it's quite possible we could see, similar to Purdue, people becoming very focused on the scope of releases in the context of that case.
Yeah, well, thanks so much for that. So let's finish up with executive compensation. And coincidentally or not, the case we're going to talk about briefly is Purdue Pharma. And what I'll tell you is that, 15, 20 years ago, every company that filed a Chapter 11 case in the US did a key employee retention plan. And it was just general operating procedure to say, hey, we're in bankruptcy. We don't want our people to get picked off by our competitors. Let's give some money to our key team and keep them in place. And there actually was legislative action on this in the US several years ago. And there were severe limitations placed on retention plans. And in particular, for compensation to quote unquote insiders, meaning officers, directors, control parties, there were real, meaningful caps on the percentage that could be paid to these folks relative to, the non-management people. And so the game shifted in the US to key employee incentive plans, which are not so restricted and which basically compensate team members for hitting metrics rather than for simply staying with the company. So Purdue Pharma filed and succeeded in getting court approval for both a key employee incentive plan for its management team and then a retention plan for the non-management team members. And I sent around the materials. I think they did a pretty good job on it. They supported it with a declaration. They market checked it. They made it fairly consistent with what they did in prior years. And, the numbers were really relative to the magnitude of of the Purdue Pharma case, the numbers were not enormous. There's in the motion, you can check it at your leisure, but the total amount of the compensation, or I should say the incentive payments for the team members was really no more than $5.5 million, up from $4 million the prior year. And I mean, we're talking about a case that has billions in claims. They tied it to a number of metrics, and really looked to be fairly correctly done. We'll see what Xiao Tong has to say. They did draw objections, and the states, the American states that were objecting to the plan, basically said, no reason to do this. You've got a new and independent board. You ought to find out what employees committed wrongdoing in connection with this terrible crisis. And it's just unsavory to be in the context of a bankruptcy where claimants may not get full payment. It's unsavory to be, in effect, rewarding the management team that perpetrated this or that participated. So, the program was approved over this objection, and I think they did succeed in making enough of a case that it was at market to get past the objection. But Xiao Tong, happy to have you with us and interested in whatever thoughts you might have on the subject.
Yeah, sure. Thank you, Jonathan. I mean, I'll just talk briefly about the Singapore perspective in relation to the Purdue Farm case. I mean, it appears to me that the general test is the same, I think, in Singapore and US, where in insolvency scenarios, the interests of the creditors, they can't be ignored when you look at the compensation packages for the management. So in a sense, there needs to be consistency with the interests of the creditors when we look at these kind of compensation packages. I did a quick check. I believe in US, there are certain clawback mechanisms that are legislated, but in Singapore, we do not have similar types of mechanisms or the kind of caps, which I think, Jonathan, you were mentioning earlier. The law in Singapore, as it currently stands, it does not allow employers to, just unilaterally reduce the amounts that they have contractually agreed to pay. So there's quite a lot of uncertainty in terms of how much you potentially can claw back in insolvency scenarios, and there's always this cost-benefit analysis which you need to weigh before deciding to pursue the claim. So, I mean, my sense is this position probably warrants a second look, at least from a Singapore perspective, following the Purdue case and also subsequent developments elsewhere. I did a quick check, and I didn't find any particularly high-profile case in Singapore courts in relation to management compensation clawbacks in insolvency scenarios. But that said, I don't do these cases on a regular basis. So Lawrence, please feel free to correct me if anything I've said is inconsistent with your understanding of what's happening on the ground.
Shadow is absolutely right. I think most of the focus for creditors in a restructuring or insolvency situation is always sort of the transactions that go between management as well as the companies, and usually, those amounts are not compensation focused. Those are usually payouts which take the form of other type of transaction payments, right?
Yeah, like undervalue or unfair, right? Kind of transactions.
Yeah, exactly. So that's the usual kind of avoidance principles that will be employed. I have seen certain companies, I shan't say which ones, but there have been a few where the management have continued to pay themselves multi-million-dollar salaries while the company is, in restructuring proceedings and struggling to pay off its suppliers and creditors. And a lot of these suppliers and creditors don't really say anything, because I think, to be honest, transparency is sometimes an issue, especially when a company is in restructuring proceedings, where everyone is very much focused on the recoverability of the debt, as opposed to how the company is continuing to, pay out on an ongoing basis while the company is still in, especially debtor in possession kind of restructuring, right? So But a lot of times, as in the case with a lot of things in Asia, I guess, when the management do say, okay, I'm not going to get paid or receive this amount, it's usually done on a more quiet basis. They don't really go out into the market and announce it, right?
Yeah,
so there can be a lot of cases where they have not taken any paychecks as well, but it's not really reported.
That's thank you, and it's an interesting point of contrast, because at this point, the only way to succeed on a program like this in the U.S. is to exhaustively market check it. I mean, I've been looking as we speak at the Purdue Pharma motion. It's 107 pages, and there are charts, there are detailed explanations of the metrics, and it's a very fine line between what's an incentive and what's a retention payment. I mean, the problem is the way you normally compensate a management team is with equity. And in a US Chapter 11, I'm not going to say equity is always valueless, but often it is. So it's kind of like you're creating a new pool of value to keep this team on board, and where you're not paying your creditors in full, and the management team is perceived to be part of the reason you're there, emotions can run very high. So it really does become important to get a good executive compensation consultant, market check it like crazy, and make an enormous record, which is what Purdue Pharma did. And to be clear, I mean, I'm being a little critical of the company, of course, but I think the restructuring lawyers for Purdue Pharma did quite an impressive job, because they had an extremely unsympathetic client in a very difficult, hotly contested case, and they really accomplished their client's goals. So fairly good lawyering, I would say. Hannah, I know we're a little past time. Anything else we ought to cover before we adjourn?
No, I think we can go ahead and wrap it up, and we can chat about when we can put the next call on the schedule.
Just the last question. Yesterday, when you sent this order, it was talking about that, okay, that amount which is payable would be treated as an administrative expenses. So is it like you are incurring it as as a cost of insolvency or liquidation, or that the priority of these expenses is to be fixed vis-a-vis the other creditors?
The former. It's a cost of administration, and it's paid in full at par, which is part of why people get angry and object to it. They're saying, hey, this management team is terrible, and they put us here, and why are you rewarding them out of our pocket? And again, I noted it was about $5.5 million. I'm not saying $5.5 million is a small amount of money, but in the context of the Purdue Pharma balance sheet, it's a small amount of money. But nonetheless, definitely the emotions are running high on this one.
I was just looking at the principle which is adopted. It's basically that administrative expenses. So that's where the things are. Yeah, fine. Okay.
Yes.